Hello there. This is Land Title Talk. I'm Stephen Collins from Land Title America. We have Rusty Collins from the Law Office of J. Russell Collins, affectionately known as Rusty Law. And as always, I have my wonderful guest here, Julie. She's not really a guest; she's our helper. She keeps us in line, and when we struggle, she gets us on the right path. But thank you for joining us. If you'd like, you can text your questions in at 904-501-4481, 904-501-4481. You can also email us questions if you like at Stephen, STEPHEN, at golandtitle.com. That's GOLANDTITLE.com. Appreciate you listening. And Rusty, what's going on in your world?
Nothing I care to talk about today.
Excellent, because I always like to jump right into my stuff, right?
Good.
So the first thing I want to talk about is leases, landlords. I know we've talked about that briefly before. But what the specifics I want to get into is month to month.
Okay.
Okay. And what's a month to month lease?
It's a rental agreement that doesn't have a defined term. So you can be month to month, you can be week to week.
Okay.
You can be whatever it is you want to on that, as long as it's not over a year.
Okay.
So
Because if it's
month
over a
to
year,
month,
then
it renews every month.
okay. There's no written agreement, by the way.
Well, you can have a verbal agreement for a lease that's a year or less.
Okay. If it's over a year, then what are the problems?
Then if it's over a year, you're gonna not be able to enforce it over a year.
Who's not going to be able to enforce it?
Either side against the other one.
Well, I mean, if this is a verbal lease for over a year, and it goes 1 year, 1 month, and the landlord's, well, let's just say it doesn't go the whole year, right?
The landlord can enforce the
it's basically it's month to month.
Wait a minute. Say that again.
If you have a year lease,
Okay.
that's verbal.
Okay.
You agree to rent my property for a year. We agree to it. We agree to a term. You start making payments, but it's not in writing.
Okay.
And I, as the landlord, before the year's up, say, you know what? I've changed my mind. Grandma's moving back into town. I need you out.
If the landlord tries to terminate the rental agreement and then tries to go to court because the tenant says, no, we have a year lease, then if the landlord were to sue or try to evict, then the tenant would have the defense of, I have a year and we're at month 9.
But it's not written.
You have to prove your terms. If you can prove the rental agreement.
Well, if the seller, not the seller, the landlord would have to say, yes, I did give him a verbal year lease.
Then the tenant will win.
Okay. But if you have a dishonest landlord, then he can say, I never agreed.
Right. So you got to figure out some other way to prove that there was
So
a
you
lease.
can have a verbal lease for more than a year if both people are going to be honest about it.
You're not, well, right. But that just means you're going to go to whatever the term is, and nobody's ever going to try to evict based upon termination of the lease because I don't want you here anymore. Okay. Or I want to move and I don't want to pay rent anymore. If you don't, everything's fine as long as everybody does what they said they were going to do.
Well,
it doesn't matter what it is.
Because if you sign a year lease, you're liable for those rental payments for a year, right?
Yes, unless your lease has the liquidated damages clause.
Okay, which
it's optional, but you can have a liquidated damages clause in a lease that says, I'll pay 2 months worth of rent as liquidated damages for terminating early.
Okay. If it doesn't have that though,
then, well, okay. The whole purpose of a lease outside of, because you can have a month to month rental agreement with all the same other terms. So it's not to have those terms. It's to have the landlord knows he has a tenant for a year and he's trading that, knowing he has a tenant for a year, for binding the tenant for a year. Okay. So he's trading the ability to increase the rent during that time for that benefit of having a tenant. The tenant's trading his ability to move out and go somewhere else without any kind of a penalty for knowing that the rent is going to stay the same.
But if it's not in writing and the landlord, he believes he has a year lease, they did it verbally, 9 months passes, the tenant's like, I'm out of here.
Well,
what
then
kind of recourse does the landlord have?
you can sue for damages
But there's no written
if
lease.
you can prove
How are you
the
going to
terms.
prove the terms of an unwritten lease?
I had a trial yesterday on what the payoff would be on an oral agreement for deed.
Really?
If
And you
can
can't
prove-
talk about that today, huh?
And well, yeah, I can, but that's like a rent to own deal. The point is,
Not
you can
really.
have an oral agreement. You just have to prove the terms. If you can
Point
prove
is,
the
you can.
terms
But I thought under the statutes of fraud.
under a year,
Well, let's say it's over a year.
well, then it's not enforceable.
Period.
Right.
So on that agreement, that oral agreement for deed, it must have been under a year.
No.
But then you just told me it's not enforceable.
You can't. Well, the reasoning that was made by the judge, and this was on a trial that happened before I got to the case, was that you can't use the statute of frauds to commit a fraud.
Let that simmer for a minute.
Right.
Explain to our listeners what the statutes of fraud.
The statute of frauds is that certain agreements are important enough that you're going to have them in writing in order to be enforced. And the sale of goods over $500 requires a writing to be enforceable.
Interesting.
Or any contract that cannot be completed within 1 year.
Okay.
Now, the weird part about that is I agree to pay you $100 a month for life.
Okay. Done.
Is it enforceable?
Well, I guess not.
Can it be?
Well, it's under $500.
No, $100 a month for life.
So
For
is
your
it,
life.
Okay.
So, is
I'd
it
be checking my
enforceable?
brake pads, my brake lines.
Is it enforceable?
Okay. Is it enforceable? Well, you just
Can
informed.
the contract be completed within a year?
No. Oh, it depends, actually.
On,
My life.
you could die.
Could.
It cannot, then it cannot, it is a contract that you could complete within a year. So it's enforceable.
All right. So, but I want to stick. So we've got a month to month.
Mm-hmm.
Well, again, I want to go back to the verbal lease.
Okay.
It happens actually.
Sure.
And if it's, let's say it's for a year and a half.
Then do it in writing.
Okay. They don't.
Well, then that will actually, it can fail. Okay.
So it's a year and a half.
The best you're going to get is if you try to break it within the year, a judge might say, well, it says, you guys agree that it was a year and a half. We're not going to enforce it more than a year.
Okay.
The whole contract doesn't fail, but we're not going to enforce after the
So
year.
let's say 12 months into it. I mean, well, let's say 14 months into it. The tenant's like, I'm out of here. The landlord wants to enforce it. Hey, we had a verbal agreement for a year and a half. He's not going to win.
Shouldn't win, though.
He shouldn't win. Why do you say it that way? Because
An oral agreement for deed was enforced.
You were on the other side.
I was on the side fighting against what they thought the payoff would be. The point is when it went to trial, this was the judge found an oral agreement for deed. So there was other things where there was agreements, okay, and they had able to prove some things. But anyway,
but so
it flies all over me. But that was enforced. So I understand you can't use the statute.
But in
of frauds.
principle, it shouldn't be enforceable if it's beyond the year. If it's under a year, the judge could possibly say, "Hey, you are still liable for the year because it's verbal."
You agree?
You agree to a
once the
year.
judge finds that it's
If the tenant's willing to admit to that.
if you have a lease, I commit to this period of time. I will pay rent for this period of time.
So if the
But here's the other part of that, though. We have to remember, if the landlord just lets it sit, and he's only got the one rental, if he just lets it sit and doesn't try to re-rent it, he may have a problem enforcing damages because he didn't mitigate them.
Right.
If he's got 5 different houses and there's two other ones that are empty, and he rents the other 2 first, that's okay.
Okay.
And then that loss mitigation is not an issue then. So he doesn't have to re-rent the one if he has other ones.
But if so, let's stick with this verbal. As long as it doesn't go the full year, I mean, or if it goes the full year or it's a little under the year, that landlord's going to be able to enforce it. But if he goes to the tenant,
he can prove that terms, yes.
But that's the important part, is that he has to prove that, and proof could be text between each other, email between each other, right?
I've won and lost trials based on text messages.
So even though it may not be in writing because nobody signed an agreement, at least proves that we had agreed to those terms.
These little things are more connected to you than your wallet.
Right.
Okay. Nobody else has this phone number unless you get some kind of weird hacking thing. So this is, why do we let people sign documents by electronic means? Because our email addresses, our cell phones, all those things are connected to us. Okay. In fact, it knows where you've been. Okay. Your privacy's gone with this thing. We've traded our privacy for the convenience. So those text messages, they can flat out hurt you if it's, so, dance like nobody's watching, but text an email like it's going to be read to you in court, because it will be. Okay. Again, I've won and lost cases based upon that.
Okay. So that's the point. And it's always better to do it in writing. I don't know why people do it.
Because they don't want to go through the hassle.
I guess
it's just between friends.
They're friends, they're buddies, but that you sure want a relationship to go sour.
Good contracts make great friends.
They really do.
Okay, because then at least you remember what you agreed to.
Yeah.
You're not fighting over what the deal was. You're fighting over what can we do now to mitigate this thing. Yeah. So that's my theory on that.
Yeah. Fences, keep T-Rexes in the park. I don't know. Just want, what is that?
He's your brother. Don't look at me that way.
Well, I always
I don't know what that was.
I know. I like the analogy of whenever you're dealing in any type of relationship, whether it be a friendship or
fences.
Yeah.
Fences. I thought you said
T-Rexes.
fences.
No, not fences. I'm not talking about the sandwich shop.
Okay.
Still.
So fences keep the T-Rex inside the park.
Right. It's,
Jurassic Park.
Yeah, we just, we need electric fences in our lives. It keeps things in check, and even with friends, it's good to, as Dad used to tell me, whenever I did anything with him, he wants it in writing so he can remember what he agreed to.
Look, things happen.
Yeah.
Okay. When I borrowed money from Dad to replace roofs, I had 3 roofs to replace. Okay. In fact, we went over what we originally thought, and I had to borrow some money from Land Title. Guess what? We're all friends here. There was a mortgage, and they were recorded. Okay?
Mm-hmm.
And the terms were fine. Okay? But we had a closing, and they got paid off. There's no question.
Right.
Okay?
There's no ambiguity.
Not that there would have been in my brain. In fact, my father did a lot of other stuff out of his pocket that I reimbursed him for. He kept a writing. Okay? So I remembered what it was. But there's no problem. But having those things does take out the ambiguity, and then if something comes up, you can at least deal with it properly.
Right.
Yeah.
And you don't have to have hurt feelings and nonsense like
my line with partnerships that I worked with is, we're going to sign the contract so we never have to look at it again, because then they know that the feet will
we
be
all
held to
know
the
what
fire.
we've agreed to.
Yeah.
And if we forget, we can go back and we can review the contract and remind ourselves.
we all have a memory that's flawed.
So these leases where people are, and again, it's their friends. I get saddened by it, but let's talk specifically about a month to month, and it's a verbal month to month. There's nothing in writing,
and you can have a written month to month too.
You can, but this is a verbal. They've agreed to what the payments are. The situation is we have this woman who is renting a home, and again, I'm changing some of the specifics. Okay, renting a home to one of her friends, and this gentleman was making the payments. It's something affordable, almost like $1,100 a month. Okay, something like that. He's been making those payments, but it's month to month. There's no agreement to the time, and 9 months pass, and unfortunately for her, her friend this gentleman is arrested.
Okay.
Now he basically says, here's access to my account. You can take the payments out of that.
Right.
And they do that for a couple months. She's ready for the lease to terminate. So first of all, how does she terminate that lease?
Well, if it's month to month, you have
Not really lease, the month to month, excuse me, yes.
then you need to give written notice
Okay.
30 days before the end of a period, and the period is determined by when rent's due.
So if, let's use December, if she collected December 1st payment, she could give notice on December 1st.
Or earlier, yeah.
Or earlier. Let's say she gives the notice on December 1st.
Right.
30 days
30 days.
on an unwritten lease.
Sure.
Unwritten
Rental agreement.
monthly rental agreement. All right. So she gives that 30-day notice. She takes the rent. Obviously, nobody's living there. This gentleman's in prison. How much time does she have to give the tenant to remove his belongings from the home?
Okay. Legally, on
That's what I want to know.
January 2nd,
On
she
January.
can file an eviction action.
All right. Well, he's not there.
But we know where he is.
We do.
And if he's not there, we can have the sheriff serve him in the jail.
He's done. He agreed to the termination.
What do you mean he agreed to the termination?
Okay,
He still
that's
has
my last month.
Right, but he still has possession.
His stuff's still there.
Then he has possession.
Okay, so his belongings denote possession.
Well, yeah.
Okay, I mean you make this sound like, oh yeah.
Well, okay, there's several.
No, not
there's
a lot
several
of
ways
us
to do
wouldn't
this.
know that. I mean,
But so in this situation, if the landlord wants to protect herself,
mhm.
then what she should do is an eviction action. Because if you do the eviction action, then you'll end up with a writ of possession. And when that writ of possession is executed, then you can put the tenant stuff on the curb. And at that point, you have no liability for it.
Okay, has to go to the curb.
Yeah. Because you
Not
want,
a dumpster.
well, you take it to the curb.
Take it to the curb.
Okay.
Now, what if you decided to take some of that stuff yourself? That's on the curb.
I don't recommend it.
Okay, why?
Well,
public.
I'd rather have somebody else take it.
Hey Joe,
I don't care
putting
what
my
Joe does.
stuff out on the curb. My tenant stuff out on the curb. Pick it up for me.
I don't really care about that.
Okay.
Okay, but here's the thing. She can take possession through that. Okay, because
How long would that take? Obviously, we can get processed. I mean, he can get served.
Well, okay, so we're not trying to terminate a rental agreement. The rental agreement has terminated because
Right.
it terminated based upon
but
the
it's got to be
notice.
30 days.
Right.
Not 15.
Not 15. That changed several
30
years
days.
ago.
Okay.
That was, believe me, that is something that I've used as a defense to
I'm pretty
eviction
sure you
cases.
have. Yes.
And again, it used to be 15 days
Okay.
on a 30-day
But
rental.
so it
period.
doesn't matter if it's a month to month. Doesn't matter if it's a year lease, 2-year lease.
If it's a
30
year-
days.
Okay, no. The statute says if it's a week-to-week rental,
hmm
7 days.
Okay.
Okay. If it's month to month, and now it's 30 days, used to be 15, but it's 30.
Okay.
With an annual lease,
hmm
I don't know what it is because I haven't had to look it up, but it's specified in the statute.
Look it up, Julie.
I will, and I'm gonna hazard a guess around 60 because it seems
It
to
might be
be what the
60 days. I
apartments
don't remember
do
the actual
because
days.
the apartments are signing over 12-month leases with people, and it's 60 days to notice. What is it called again?
Oh goodness,
Forgot.
we'll just fix it. Okay, anyway,
Hold
but
on.
so there's a time.
We're
frame.
looking to see how long a lease,
Yeah.
a notice for termination of a lease over a year. Let's say a year and a half. You don't have to look it up.
I'm just going to get the statute. I don't want.
We ain't got time for you to do that.
Sure you do. Anyway,
Can you talk and type?
Yeah.
Okay.
the lease is already terminated, so now you have a tenant in possession that you want out. Okay, even though they're not there.
But here. So if I have a year and a half lease, Rusty, they already have noticed the lease is up. I should have
Right.
good notice.
Well, but if it's a renewable lease, okay.
Let's say it's not renewable.
Well, then if you have a lease that says this is not
It
renewable,
terminates here.
you must have a new lease.
Mm-hmm.
Okay. Then you're at that time, you're a holdover tenant at the end of the period.
So they're not out at the 1.5 year mark. They're not out. I gave them notice I'm not renewing the lease.
Okay, so here's the deal.
Because that's an important.
If you
60
have
days
it-
in Florida, and it ranges 30 to 90 in the United States, depending on the state.
So it says when the tenancy, if you don't have a specific term, okay.
Okay.
So if the tenancy, remember, if you say it's a year lease, my tenancy's for a whole year. Okay. If we don't say that it's over after the year,
Mhm.
so it's renewable every year,
Mhm.
then you have to give a written notice that 60 days prior to the end of the
See, I would have
of the
gotten that
period.
wrong.
Okay.
If somebody would have asked me, I would have said 30 days.
Okay. But that's if it doesn't have an actual ending date. Remember, tenancy is the period. Okay. And a term is when is it over? The contract over.
Okay,
So-
but if it has a term, specifically a 1.5 year term,
Right. So, if the tenancy is year to year, 60 days. If it's quarter to quarter, it's 30 days. Month to month, 30 days. Week to week, 7 days.
and if it's over,
60.
Is this saying well, you're not going to have an oral agreement that does that.
no, I'm
Um,
just saying the tenant has notice. If it's a 1.5 year lease, they have notice.
Right. But every year and a half lease I've seen, like with apartment complexes, it says that if you don't have a new lease, you're a held over tenant,
Mhm.
which means your rent doubles and we can kick you out.
Okay. And
Okay.
you have to have that terminology then in your lease.
Right.
Okay.
Right. That's you just have to understand that's how we do it so that there are no questions.
So how long would it take for a landlord who's got a bunch of furniture and things in her house that she needs to move somebody else in?
Okay.
She's
So-
already given notice on the 1st of December. January 2nd, then she files an action.
It's going to take, you file on the 2nd. If you're not a lawyer and you don't have to wait, if you walk in and you walk out with, you pay the $40 and your summons is issued right then and the numbers are there. When I e-file it, it might take me a day,
Okay.
sometimes more than a day, but I can call and get something.
All right.
Take
So the
that pretty
second
quick.
comes, they
They can actually get it to the sheriff on the 2nd in the afternoon. It gets served on the 3rd. Then you've got 5 business days, and if nobody's filed an answer, they can be defaulted, and you can ask the judge for a judgment of eviction. And if you have a cover letter that says, "Hey, he's incarcerated. He's not coming out for a while. I'm just doing the formalities here to get my writ of possession," they'll probably do it right away. And
how long
then,
would a judge? So you have 5 days.
then you have to ask for a clerk's default.
Okay.
You
And
get
I
that
ask for
done.
the clerk's default. Clerk
And
gives me the
then-
default. Then I've got to schedule something with the judge again.
Well, no. What you do is you get the judge the order, okay, and you don't just say here's an order, sign it, and have the judge figure it out. You have a cover letter that says what's going on,
Okay.
and you see the judge can verify if the person's in jail. He can verify that real quick,
Right.
and he can know that we're not doing anything sneaky here, okay. And you have a cover letter that says I'm just trying to get my stuff or get the stuff out on any writ of possession so I can be done with it. Then fine. Okay, you get that done, and you can be done.
So if
and
they
over
hire
with.
you to do it, they come to you on the 2nd, say, I want this done quick. How quick on average?
It's going to take 2 to 3 weeks,
All right.
depending
So
on.
you're
what
going to
else is
lose a
going on.
month's rent period no matter what.
Oh, you're going to lose. Yeah, that's almost a given. But
And there's no way to speed up this process. What if it's a month, what if you gave them a notice that it's going to end on January the 2nd and you notify them in November?
wait a minute. I mean, it's going to end on January the 2nd. When's rent due?
Excuse me, January the 1st.
Okay.
I apologize. I got stuck.
Well,
on
then
that.
you've got your at least 30-day notice, right?
I mean, there's no way to speed it up. There's just no way to speed it up. You're going to have a month's
And
of
here's
lost
the-
rent
and
period.
here's the other thing that's kind of weird. If you want them out, if you want to terminate it effective December 1st, when you need to give that notice.
No, I guess since, November, I guess it'd have to be September 20.
October 30th or 31st. Yeah.
Okay.
Here's
Yeah,
some
that's
other
right.
things you got to worry about.
That's right.
If the beginning date okay, you don't count the day you give the notice, right?
Right. That's
If the next day is a Saturday, Sunday, or holiday, you count the next workday.
really okay. It doesn't count
And
for
if
holidays.
the last day is a Saturday, Sunday, or holiday, you count the next day is the next workday is the day that matters. How many holidays are there in a year? Well, if you're in Duval County, Juneteenth is a holiday.
Okay.
If you're in St. Johns County or in in our district, the Seventh Circuit, Rosh Hashanah and Yom Kippur are holidays, but not Juneteenth. So there's you have to look at the calendaring system.
Interesting.
So sometimes the devil's in those details that
Devil's in
aren't
the
the same everywhere in the
details.
state.
Yeah.
So, but you got to do it a certain way. Now, let's just say, what if your rental agreement hasn't expired and you've stopped getting rent and the person's run out of money?
Same principle, right?
Well, maybe.
Is it?
Well, you can the statute says you can retake possession of the premises in like 3 different ways. Okay. One is, hey, I'm out, here are the keys. Okay. That's an obvious situation. The second one is the sheriff puts you in possession after
That'd be a normal eviction.
writ of possession.
Right.
And then when the tenant has abandoned the premises, okay? And how do you know? Well, the statute says if the rent's not paid,
okay,
and you don't have like real notice that they're coming back, okay, or when they're coming back.
They just went to go visit Europe on a mission for 3 months.
Well, okay, you don't have notice.
You abandoned the property.
You don't have notice that they have not abandoned, okay?
Right.
If the rent's not paid and 15 days has elapsed, you can retake possession.
Yeah, but you just can't walk in and take possession.
Yeah, you can.
But that's if they've abandoned the property only.
Right, which means the rent's not paid
Right.
and they've been gone for 15 days.
15 days, you just go in. There's no.
It-
But what about their belongings?
Well, we have a way to get rid of that too, which is not taking it to the curb. Okay?
Which is what?
Which is you have to give notice. There's a statute for it. It's not part of the Landlord Tenant Act, but there's a statute for it that says you have to give them, get the mail them a notice.
Okay.
Okay. And you give them 10
And
days.
does it have to be any kind of proof? You can regular mail.
Well, if you hand deliver it,
Okay.
it's 10 days for them to fix the problem and come get it. If it's by mail, it's 15 days. It does not require certified mail.
Okay.
Okay. And after that, you can sell it however you want. You can dispose of it. You can keep it.
Their belongings.
Yeah.
If they've abandoned.
Right.
Wow.
You can
Okay.
also charge reasonable storage fees for them to come pick it up to get their stuff too.
Well, if you're in prison,
It's
is that
kind
a
of hard.
form of abandoning?
Uh,
I don't think so.
you're not there.
Yeah.
You're absent for 15 days, and we do not have any notice of some other intent. But so the abandonment keeps you from having to evict.
Okay.
It may be quicker to evict. In
Well, you
St.
said it's
John's
3 weeks, though.
in St. Johns County, it's probably quicker to evict.
How long?
Well,
Roughly.
you don't have to wait the 15 days. Okay. If depending on when things fall on the week, okay, you get it filed, get it served, 5 days elapse, ask for a default and get the default, ask for the default judgment. Even though we have our eviction docket and stuff, the court does not really hold things up, even though we have the court has to do certain things. There's statutes that require certain policies by the court. When somebody files an answer, but they don't put money in the registry, they're going to interpret that as a request to determine rent, how much rent the person has to deposit in the registry in order to defend. So we're going to have a hearing, but if they don't do anything and the landlord goes after a default and then files a motion for default judgment, then the court's going to probably issue the judgment because they should. And again, because we have this eviction court, we're kind of bending certain rules a little bit, but we're enforcing them in a way that benefits everybody. People are getting a much better opportunity to try to work something out so they don't have an eviction for those who are just having difficulties. And they have we have legal aid lawyers or people that are volunteering for legal aid to help to try to get something. And, but it's a way to make it quicker. Before it was hard to get a hearing. Now we don't have to do that here. In other counties, now in Duval County, they don't have any patience. They kind of streamline it, and it ABCD, no answer. We're given the default. Here's your judgment and writ of possession. So right now in Putnam County, we had one judge that stepped down and another judge that retired.
Wow.
There are 2 judges down. So it's going to be harder in Putnam County.
Want a job?
No. You have to live in Putnam County. I don't.
Excuse me.
We're glad.
Besides, I'm an advocate.
Yeah, well, you'd be a great judge.
I'd rather argue it than decide. I don't want to be the decider.
You'd still be a great judge.
Yeah. Anyway.
But on this topic, again, I think it's something we've talked about before. Self-help is a bad thing. Especially if you're a landlord thinking that, well, I got a tenant that's behaving bad.
I'm the king.
And I'm going to shut off their electricity, or I'm going to.
We love those guys.
Well, you like those guys because you go out and kick their butts.
We get fees.
Yeah, you get fees, but you can't do anything like that. You have to play by the rules, which is you give your notice, you file your case, you get an attorney. Trying to do it yourself.
Okay, but the landlord.
How much does it cost for an attorney to do this?
I'm charging $1,800 to $2,000 to do an eviction case, and that includes the filing fee.
How much do they have to if they do it by themselves?
It's $180. It's $185 to file it, $10 for each summons, and $40 for the sheriff.
How do you know it's getting done right if you don't have an attorney helping you out?
How you know what's going to be done right?
If you're doing it right. I mean, there's still a process.
They have a form.
You
can download the form.
They have a checklist.
They have a form. You fill it out. Okay, and it's fairly good English. It's easy to read. Right. Even a lawyer can understand it. It doesn't take 5 of them to figure it out.
You can figure it out. That's a good sign.
So it's easy to understand. Mm-hmm. They do have some instructions, but they're not going to give you legal advice. But if you can read and understand English, you can probably get it right. Okay. And the summonses are done by the clerk for those, and you pay the money and they get served. It's fairly simple. Now, if you got anything that's weird or you don't want to have to deal with it, the lawyer's a good idea. But now there are eviction mills that probably do it for less than what I would do it for. Okay. But we're here and we can run and do and go and.
But the key is don't.
You can do it yourself if you want to.
I can imagine how frustrating it is if you are a landlord that is depending on that rent payment to make your mortgage payment.
Then if that is the case.
And it happens. Okay, right. It happens.
But if that is the case, then if rent's due on the 1st and you didn't get on the 1st, you're there on the 2nd with a 3-day notice.
And that 3-day notice says?
You owe me this for rent for the property. And we're talking about this month, not last month. Okay. Mm-hmm. And you have until such and such a day, which is at least 3 business days away, to pay, or terminate, or the tenancy is terminated.
And the lease terminates.
Well, yeah, it doesn't terminate. They're in breach, and you can still sue them for money damages afterwards.
I mean, you can sue them for the rest of the lease. Yeah,
you bet. Yeah. But here's the thing: if you give the 3-day notice on the 2nd of the month, and they say, "Look, my rent's $1,000. I got $500. Will you take the $500?"
Is right the answer
now, no? I would say take the $500, and at the same time, you hand them a new 3-day notice for the other $500.
Okay.
It resets the time, but you don't lose your rights to evict.
Especially if you need that money.
You're resetting the deadline when you do that to another 3 days. So we're encouraging the tenant to pay, and we're encouraging the landlord to take it. Okay. Now, if you're talking about a rental, an apartment complex, they're not doing that.
They're not going to take half.
No. But with individuals who are trying to make their mortgage payment, that can be a way to do it, but you got to stay on top of it, because if you wait the 10 days, or whatever to get on the stick and try to enforce your rental agreement, then you're 10 days behind, and now you're going to be late on your rent or your mortgage payment.
Right.
And so if you stay on top of it, then great.
But I understand the emotions of a landlord who has that stress.
But it's not personal to hand somebody a 3-day notice on the second of the month.
But they can't go in there and start locking doors or changing locks or.
Only if they want to pay me money.
Well, is that criminal in any way, shape, or form? I mean, because possession, Rusty, is a big thing.
Okay, so
the tenant is in possession.
That's right. So here,
even if they've not paid their rent for 6 months, they're still in possession, right? Unless you follow the legal actions to get them out, they're in possession. You just can't break in my house, get out.
I had somebody I knew, and they called me one day and said, "Hey, the landlord just came to our house, and they wanted us to leave because we're behind on our rent. And they took our TV and our Xbox and left and said we can have that back when we can have those back when we move out." I said, "Call the non-emergency line at the sheriff's office and get a police report done."
Because that's thievery.
It's not thievery. It's a different thing.
What is it?
Okay.
If somebody breaks in my house and steals something,
they were there.
theft.
They didn't break in. They walked in the front door.
That's still breaking in, whether or not I have my front door locked.
Okay.
Okay, fine.
They entered the dwelling house of another that was occupied and committed an offense, which is taking stuff without permission.
Okay.
Because that is theft. But when you enter the dwelling house, dwelling of another, okay, and commit an offense, we have a term for that.
Okay,
it's called burglary.
Okay, burglary. Sorry.
Okay, stealing is depending on value.
Burglary.
Stealing is a misdemeanor.
All right.
Burglary is always a felony. Okay, so it's
not
occupied
thievery. It's burglary.
Yeah,
It's robbery.
no, robbery is when I take something from you personally against your will under the threat of violence. That's robbery. Yeah.
Interesting.
I'll fight you to the death on that one.
Not looking to fight, just looking for clarification.
Yeah, I can steal something, but if you don't give it to me, I mean, I can commit theft by trick. Okay, if I can talk you out of something by lying.
But this was burglary.
It's burglary.
Okay.
And so the next day, I went and visited him.
In jail?
No, I visited my client.
Okay.
To see how things were, and while I was there, Mr. and Mrs. Landlord showed up.
Oh, really?
Yeah. And when they were walking up, I said, "Call that deputy and get him back here." I went out, handed him my card, said, "Hi, I'm Rusty." And they were surprised how their tenant who couldn't afford to pay rent could afford an attorney. And I said, "Well, I don't get paid by tenants. I get paid by landlords." And
Gosh.
the
You told him that?
I did. And then the deputy showed up and said, "Mrs. Landlord, can you come over and talk to me for a minute?" Which is code for, "I just want you away from everybody else. I put you in handcuffs."
Mm-hmm.
She got hauled off to jail.
How old was this landlord?
40s probably.
Okay.
Okay.
They're young.
Young. And
Now
then
that I'm 57,
Mr.
it's really young.
Yeah, I know.
Whippersnapper.
Mr. Landlord ended up in handcuffs for a little bit, but they released him. Now, those charges didn't stick. Okay. It was
Why wouldn't they?
the prosecutor didn't prosecute the case.
Why?
Because they didn't want to.
I get it. I mean,
Okay.
I understand.
They got stuff back.
I'm pretty sure, again, I feel for these landlords that they shouldn't act badly, but I understand the stress. I mean, I can only
And
imagine.
you have to understand, I would never rent to these people that I know. They're pigs.
Okay.
Okay.
Put it lightly.
But that is not the analysis.
Right.
So we want people to look, our landlord tenant law.
By the way, that was an official legal term.
Yes.
Tonight it is.
What?
Tonight.
No, it's official legal.
No.
They were pigs.
Okay.
Okay. I think I actually did an article
Just
about
try.
it, and I think we used the three little pigs.
Oh.
But the point is this: our landlord tenant law is structured to get a fast resolution. Okay, there are certain things you cannot put in a rental agreement. There's certain things a landlord cannot do. You cannot. It's not a kingdom. You cannot be. It's not a fiefdom. You don't have absolute power. But we want you to get paid, and we have a quicker way. You know, most lawsuits you get served, you got 20 days to respond. In a landlord tenant action, you got 5 days to respond for for possession, the possession part. But if you put up any defense other than I paid, or I don't know how much to pay, tell me how much. If you don't put the rent that they say is due into the registry of the court, that is you waive all defenses. It's an absolute waiver of all defenses, and landlord is entitled to a judgment for possession without further notice or hearing.
Well, let's change it up a little bit. Let's say you're the tenant, and the AC breaks.
Okay.
And you're like, listen, landlord, fix the AC. We're dying in here.
Is the AC a part of the rental agreement?
Yes.
Okay.
It's not. And besides, what tenant is supposed to be responsible for the AC unit if it's not
I'm not
commercial?
saying that you're, no, I'm saying is the use of the AC a part of the rental agreement?
Yes.
Okay. Because you have to provide heat, but not necessarily AC.
Okay.
That's true.
It has an AC unit.
Okay.
And that's what provides the heat or the cool.
Okay.
That breaks.
Okay. So while you are not in default on your rent, okay,
Uh-huh.
you give them a notice to fix the bloody thing.
Okay.
If they don't, then you can do what you need to do. You can either fix it, withhold rent and fix it, which I don't recommend.
Why?
Because they may have, you don't know if they have a contract with somebody. You don't
Okay,
know.
but if you
So
call,
what you
if you
do-
call up the landlord and say,
No.
yo, man,
What do you mean call up?
hey, Mr. Landlord, the AC's broke.
Why would you call them?
Why wouldn't you?
How's that enforceable?
Fix it fast.
No. You give them a written notice.
Yeah, but okay.
Now, we changed the law. You can have a provision in a rental agreement that says that we can do notices by text message. Okay. But you give them a notice that says, this needs to be fixed. It's wrong. It's part of my rental agreement, and I will withhold rent if you don't.
And you legally can do that.
Right.
Okay.
So then,
As long as you give them notice, how much notice do you have to give them? Because listen, I don't mean to be a first world problems, right? You know, oh, my AC's broke. It's into the world. You know, that's we tend to, but really there's certain creature comforts that we expect.
well,
And
the
that should be
landlord
one
that's a violation of the obligation to maintain the property.
Right.
Okay. So that's what you're saying. It's not, hey,
Yeah.
my AC's broke, you got to fix it. It's a violation of maybe they don't know. That's why you got to inform them. Okay.
Right. But I say you make it. And if for whatever reason it takes them 3 weeks to get this done, you have no recourse as long as they get it done. What's the deadline? At what point do you as a tenant say, you know what, this is too long. You're toying with me here.
There are provisions in the statute I'm trying to bring up, but it's not helping me here.
Okay.
Something's not working. And again, this stuff is important. That's why I refer back to the statute.
No,
I don't have
agree.
it committed to memory.
I agree.
But there are provisions.
I mean, if I'm going to
can't-
bring it up and I don't give you heads up because I
Yeah.
like it,
right.
I like
So
putting you on the spot, I guess you should be able to have the time to look it up.
the landlord has an obligation to maintain the premises, right?
Right.
Okay. Certain things there's an obligation for it. And this thing's not cooperating.
Okay.
And it
Anyway.
used to be if you withheld rent, it had to go into an escrow account. Does that
No,
still
you
need
just
to
don't want to
happen?
spend it.
You just don't have to do that anymore.
Well, so let's say, all right, so I've withheld the rent. Okay. I'm holding the rent. Landlord gets frustrated and, okay.
Tries to evict.
Well, first of all, the AC and the notice didn't happen on the first of the month. Okay.
Okay.
Let's say that first. Okay. Because that becomes kind of like, you ain't got the money.
Right.
Okay. But let's say you're legitimately
And you go out there
withholding
to find
rent.
that the AC hoses were just cut. Just kidding.
Well, but if legitimately something is wrong, okay, and you've given notice, the landlord doesn't get paid. So what does he do? He gives you a 3-day notice, right? Well, you feel like you have a legitimate situation here. So then the landlord, you don't pay the money. So the landlord files an eviction. What you going to do?
Put the money with the registry of the court.
You put the money in the registry of the court.
Okay.
Okay. Now the court has it and the judge can decide what to do.
Okay.
Okay. So you've
we've had
protected yourself.
We've had other cases where it's not necessarily just an AC unit. There's a damage to the roof, and there's a room that's got mold and leakage, and and they have issues like
if
that.
you got a mold and leakage, then you might want to terminate the rental agreement. Okay, because why do you want to be with mold?
Right.
Okay, just because there's mold doesn't mean the landlord has to fix it. Just means you can terminate the rental agreement. You know, I a lot of times I see cases where, you know, this place is uninhabitable, but I don't want to move and I don't want to pay rent.
That's not going to work.
It shouldn't work. That's a bad idea.
Have you seen it work?
No.
Okay.
So
if
you think this place is uninhabitable, but you don't want to move,
right,
why do you get there, move there for free,
right,
or live there for free? You don't.
right.
That's
But you
not-
can demand that the fix be made, right? Can I demand, hey, Mr. Landlord, you need to fix this room. You need to fix that roof. you
Or
need to
I'm
fix
going
the
to terminate the rental agreement.
or I'm not going to make my payments.
No, wait a minute. You're going to, okay, I understand withholding rent for a minute for certain things to be fixed.
Or I'm not going to make my payments until these are made, until these are fixed.
If the place is uninhabitable.
No, the room's uninhabitable.
Okay, well, yeah,
Not the
but
place.
so the mold
I've
stays
shut-
in one part of the house.
I've shut the door. It's in that part of the room. It's in that part of the house, but I can't use that part of the house now because of
Then,
their failure to fix. And I'm
Right.
like, I'm not paying my rent till you fix this.
well, you need to make sure that what you're withholding is the right version of that. Because if you have rent that's $1,200 a month and you got one bedroom you can't use, well, how much is that bedroom
But
worth?
I want to use the rent as an incentive to pressure him to getting it done.
Okay, but you're not. You can withhold.
I don't
the
want to
amount.
leave. It's next to my kid's school. I like the church I go to. I want to stay in this home. I've got a 2-year lease and we're 6 months into it. This room is uninhabitable. The landlord's basically giving me the middle finger. I'm not going to pay my flipping rent. I will put it aside, but you're going to have to fix this room. And by the way, I'm going to deduct the prorated share of that room that I could not use during the period that you refused to fix it. Mr. Rusty, will you represent me?
With certain caveats, yeah.
Like what?
Well, I'm going to help determine what that was worth.
Fine. I agree with you determining
Okay,
what that's worth. Would you represent me?
probably
Okay.
because again, that had the statute's made to help with that. But
Right.
if you're telling me that my kids are getting sick from the mold, I'm going to say, get the heck out. Terminate the rental agreement and get out. You
Right.
can terminate without breach on your end. Okay. There's a lot, my experience with tenants who've tried to come to me for help is they feel like sometimes they need a whole new house. We want you to,
Right.
to build me a new house while I'm not paying rent, and I'm not going to pay rent until you build me a new house. And then I'm going to want to inspect it. And,
So
There's-
is there a way
reasonableness.
for a landlord to so a tenant comes to me and says, listen, I want this room fixed. The landlord guys, hey, listen, I've already fixed the roof. I've had mold remediation done. And the tenant's like, well, we're still getting sick. We don't like it here. We need you to keep doing more work. And the landlord is like, I'm not doing any more work.
then if he can't do it after he's used his best efforts, he can terminate the lease.
Okay.
Okay.
What are they like? We don't want to. We want to force you to fix it.
No. I've
Okay.
terminated the lease. Get out.
Gotcha. But they have a 2-year lease.
Right, but I can't fix it.
Okay.
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 If you can prove damages, fine, but you're moving. I can evict you. You may sue me for damages. Okay. But that's not what we're talking about. We're talking about possession now. Okay. And I think if you've done everything you can do and you can't fix it, things that are reasonable within your ability to do it.
Right. I mean, there are users of the system out there. trying to think
There's
of
a lot of,
others,
and
yeah.
believe me, I'm coin operated when it comes to landlord tenant. I can work either side, but the rules are the same. Okay. I examine the facts. It doesn't matter which side I'm on. Landlord tenant is some of the easiest part of Florida law because the rules are very simple and easy to read.
All right. So, in the example I gave you where a tenant comes to you and says, listen, I need your help in representing me. I can't get the landlord to fix the AC or I can't get the landlord to fix the mold in this room. How much would that cost them on average?
That's probably going to be an hourly type thing. So it depends on how many hours it takes. If I got to take 5 hours, you're looking at $1,600,
But
$1,700.
does the tenant have any relief under the contract, under the lease agreement, to get reimbursed their fees because of a bad acting landlord?
Okay, so here's the situation. If the landlord materially fails to comply with the requirement to maintain the dwelling, or the material provisions of the rental agreement. So like, you don't have to have AC under the statute, but you do most likely under the rental agreement.
Yeah, but if I rent the place and it had an AC unit when I rented it, that should
I
be
didn't
expected.
guarantee that it was in wonderful working condition. That would be a contract item. Okay.
That's something that's pretty
Okay.
interesting.
But that's why you have a written rental agreement.
Right.
Who's, the form that the real estate agents are allowed to use to make a lease.
Takes care of all that.
There's a check the box of who's in charge of what.
Right.
Okay.
Right. I guess
and-
that even on a residential lease, you can be responsible for the AC unit.
Sure.
Washer and dryer, but it says if the washer goes kaput, you got to get your own.
Right. We're not warranting that these things work.
Right.
Okay. You do have to provide heat.
Yeah.
Heat.
Yeah.
Okay.
Let's put it this way. You
That's
cannot terminate the heat. That's like terminating the electricity.
Okay.
That's the same thing for
but you could sweat.
mortgages.
There's nothing.
They care about heat, but they don't care
people
about
lived here
AC.
before we had AC.
I
Mhm.
get it.
I don't know how,
but they had
did.
jealousy windows. This is what they
Okay.
did.
Okay, they had tents too.
Yeah.
Whatever. All right.
I don't know how
So
they
if
did
they
back
failed
then.
to comply with the obligation to maintain or a material provision of the rental agreement, if they fail to comply within 7 days after delivery of a written notice by the tenant specifying the noncompliance and indicating the intention of the tenant to terminate the rental agreement by reason of that, the tenant may terminate. If the failure to comply is due to causes beyond the control of the landlord, and the landlord has made and continues to make every reasonable effort to correct the problem, the rental agreement may be terminated by the parties. Okay, they can they don't have to terminate it. They can, or they can modify it. Okay.
Yeah.
If the landlord's failure to comply renders the dwelling unit untenable and the tenant vacates, then they're not liable for rent for the rest of the period.
Okay.
If the landlord's failure to comply does not render the dwelling untenable and the tenant remains in occupancy, the rent for the period of noncompliance shall be reduced by an amount in proportion to the loss of rental value caused by the noncompliance.
Okay. Well,
That's
that clears
why
up
if the landlord, you don't come up to a deal, and the landlord goes to evict you, and you put money in the registry of the court because you're paying your rent and you're protecting yourself, then a judge can say, okay, I find that loss of this room is worth 25% of the rent or 10% of the, whatever it is.
and they can pay the legal fees with that
something, yeah.
Yeah.
But
because they've already had to put the money at the registry of the court. I mean, that money's there.
they put the money in the registry of the court. Well, if whoever wins, they can get attorney's fees.
Okay.
Okay. So
All right.
that's the idea. Okay. But you don't get to stay there and not pay your rent. Okay. That is full of gamesmanship. And if you've been doing any kind of real estate work for any amount of time, there are people who become professionals at this.
Right.
Okay.
Gaming the system. Or
Gaming the system.
trying to game the system.
Right.
Because then you have this, which we don't have time to really hit it, which we'll talk about some other time. People who move into a vacant house and just,
Oh yeah, but we got remedy for that too.
well, that's a recent remedy, isn't it?
Yes, that's a
'Cause
recent remedy.
that wasn't something that was always there. You have these squatters move in.
Yeah, people just move in.
Right.
They weren't invited in. They just move
Just
in.
moved
take
in,
over.
took possession.
They can be removed without
How quickly?
Today. The
Okay,
sheriff
what's the
will arrest
process?
them.
So let's
I'm gonna
say
look
I
at the
have a
statute.
house, whatever. It's sitting vacant for whatever reason
Somebody just you come
Squatters
back
just
and
move
it's like,
in.
where they are. Where do people come from?
because it used to be difficult to get these people out.
Well, not difficult. It just took time in the due process.
So now what's the process? I
Well,
guess we have enough time to talk.
now you would get the sheriff to have them move. Like right now.
No, there's no court proceeding, nothing.
If I'm the owner and I say these people were not here when I went on vacation and
I'm
they're
sorry.
here now,
Rusty told me that I could move in.
where's your writing?
We didn't have anything in writing. He verbally said he's lying.
Yeah, good luck with that.
Well,
Okay. I can just tell you we fixed that problem and we're not going to become like a lot of these other states.
Yeah.
Okay. Now, I remember when they did change. If somebody moves into someone's place and makes it their home, like the guests that won't leave,
Yeah.
okay, and they are getting mail, they've changed their driver's license, all that stuff,
Right.
then you're going to have to use an unlawful detainer case to get them out.
Yeah.
But if you've got unlawful entry, okay,
Which is different because in the case of of a person you've invited in, you've invited them in.
right,
They're living there.
right,
That's a more difficult situation to remedy.
right. But so we had, and now if you have the guest that comes over for a week and they have another residence somewhere,
Right.
okay, and they don't leave,
Right.
you can do an affidavit, give it to the sheriff, and they will basically trespass them. Okay. They come back, they can be arrested. Now, when that first changed, I did one of those. And the deputies laughed at my person. So I sent an email to the undersheriff, who is also an attorney, and said, is it the policy of the St. Johns County Sheriff's Office to not enforce this statute? And they changed their mind.
And quickly did it.
They quickly did it.
Yeah.
So that you kind of have to understand that some things change. And again, you can't use these things as swords. You got to use them as shields, right? Now, if you have the person that
Very wise.
I like
that
that.
Sounding there,
moves,
Rusty.
that right,
It happens every once in a while.
right, every once in a while. So now, what if you have the person who just moves in, and they present law enforcement with a fraudulent lease?
Mm-hmm.
That's a crime. Presenting that lease that way is a crime.
Okay.
And so we don't like it. We are not going to put up with it. You still can't do it yourself, and there's no self-help here. Okay? That means law enforcement does it.
Yeah, you can't take the friend and start beating him up and kick him out.
Right. At least not in the city.
In the county,
You know, if you're south of Division Street in Flagler State, I don't know what you might be able to do.
Just don't do it at my house. I'm in the city limits.
I'm just saying, you know,
yeah,
you don't want to get caught doing that anywhere.
yeah,
But,
Emphasis on don't get caught.
right.
okay. I mean, we
But
can
I'm just saying, again, we want to protect people's rights, even the landowner's right and the person in possession's right. But if they're committing a crime, here's the thing. If you just move into somebody's house, if you just take possession without permission, isn't that theft?
I would agree.
If you take possession without permission, it's not the dwelling of another, a dwelling because they don't live there, okay? But it is theft. And if it's where they live, it's burglary because you're taking the value of
Okay,
the
interesting.
rent, okay?
Yeah.
So, if you take
But
an
if you
abandoned...
take possession of real estate, fence it in, and pay taxes on it for 7 years,
Well, wait a minute. Let's talk about this for a minute.
we're not
Okay.
gonna get off on that. Go ahead.
My point is, if you take possession, because you're going to get adverse possession, well, you got to do something before you take possession.
That's correct.
You got to pay the taxes.
I got all that.
You got to file something.
I didn't mean to distract you.
You do that, okay? Then you're fine. But, and if you do that for 7 years, you've met the obligation, and you can get adverse
Rusty, I
possession.
apologize for bringing that up.
But but I'm going to the next part.
I should
If
have
you
never
take
done that.
possession and then rent it to a third party, you're now stealing rent,
Okay.
and that is a crime.
Okay.
Even if you file the right stuff, okay, you do not have the right to do that. And I've learned that in representing somebody.
Oh, did you represent the wrong guy or the right guy?
I represented the wrong guy,
Okay.
okay, and me and our buddy Mike Taylor had a chat
I bet you did.
on behalf of the state attorney's office. And even though I disagreed, I didn't want my older client to be a test case sitting in jail while we're arguing in the appellate
Right.
court. So again, we're the commonplace that matters. Okay. So I'm just saying we have rules and laws to protect people. Okay. And our legislature and our governor have made it to where that's happening. So don't get away with just squatting. You have to do certain things. And landlords, you can't be a jerk. Okay. You can enforce the provisions of the law. We have a great method for doing it. Gives you a faster resolution. But tenants can't be psycho either.
Right.
Okay. You got to do it right. And we want landlords to do the right thing. We want tenants to do the right thing. And if you can't pay your rent, you need to move.
Rusty, how does somebody find you?
Don't find me. No, 904-829-6600. Call Ben.
I said find you, not find you. Yes. Yes, you can find Rusty at 904-829-6600. That'll be 6600.
And if that doesn't work, just find Steve and he'll FaceTime me.
Yeah,
that happened today.
Yeah, that's right. I'll FaceTime if I can't find him. That's the best way to get you sometimes. And I'm Steve Collins from Land Title of America. You can reach me at 904-797-9600. That's my office number. But if you'd like to get to me personally, 904-501-4481. I love texting. 904-501-4481. Remember, it's expensive to be right. Always insure your real estate ownership. That's what we do at Land Title of America. We also handle all types of transactions from commercial, distressed properties, tax sales, foreclosures, and your normal run-of-the-mill residential transactions. I'm having a hard time speaking today. But so give us a call. We'd love to help you out. We appreciate you listening in, and we'll see you next time. Julie, thank you very much. We'll see you next time.